There's more. Thank you. No, thank you very much, but we'll follow up.
All right, follow.
Thank you very much. Thank you very much. The next witness is Mr. Ostertag, former president of the New York State Bar Association. Mr. Ostertag, how are you, sir?
Good afternoon, Mr. Chairman.
How you doing?
I have a question, if I may, before you run the clock. Is there a rule, does this committee have a rule about the surreptitious videotaping of witnesses who come voluntarily before this committee to testify?
We don't have a rule because if you notice, the proceeding is being videotaped.
I don't mean that one.
Right. The proceeding is being videotaped, and this is open to the public, so, you know.
Well, I've been videotaped by Mr. Gallison, I think.
Oh, you and me both.
I don't know where he is now. He was sitting over here. Then he was over there, and then he was up against the wall, and he was sitting over here, and then he was up front, and now he's up against the wall. At least you were videotaped. He tapes record you too, you know. I don't know.
You say around him, man.
I don't know Mr. Gallison. He was videotaping the faces of Mr. Friedberg and Mr. Gold, who I also don't know.
No, I would understand that, Mr. Ostertag, but the proceedings are open to. But Mr. Gallison, could you cease the videotaping to allow? I want our witnesses to feel comfortable to testify. Thank you.
Well, I was going to give him the finger, but I didn't think quickly enough.
I'm glad.
My name is Robert Ostertag, and I am here on behalf of the 76,000-member New York State Bar Association. We are a voluntary association devoted to the concept of lawyers serving their clients consistent with the highest standards of professional integrity. I would like to get back to what I am here for. I have no complaints about anybody. I have no inquested accusations to make against anybody. What I want to address is the question of when disciplinary proceedings should be made known to the public.
Okay, that's
and in considering this question, we need to take note of the legitimate competing interests that are involved. For lawyers, their competence and reputation is what they offer to the public. It affects how they are viewed by individual clients, judges, and the community at large. The arguments and viewpoints of a lawyer with a good reputation will be heard and carefully considered, whether by his or her clients, the court in which the lawyer appears, or in the general community. Lawyers spend years, a career, trying to earn a stellar reputation. A good reputation cannot be bought or easily gained. It can be achieved only by a lawyer's demonstrated actions and efforts on behalf of clients over a period of time. Gaining the type of reputation for which all of us strive requires demonstrated skill and expertise on a continuing basis. Unfortunately, however, an earned reputation can be lost, and it can be lost in a mere moment.
That's true.
I've practiced law for 50 years. My reputation, I think, is beyond repute. I recognize that it can be lost in a mere moment.
You're right. Correct.
For clients, they are entitled to know that any lawyer they retain has integrity and meets the standards of our profession. When serious questions are raised about the ethics, competence, trustworthiness of a lawyer, a client is entitled to know. The Bar Association understands that we should not have a disciplinary mechanism whereby clients are unknowingly represented by lawyers who may not meet those professional standards. The problem, of course, is that when a complaint is filed against a lawyer with a disciplinary committee, the complaint may or may not have merit. If the fact of the complaint is disclosed and it is later found to have lacked merit, the lawyer's reputation will have been affected, obviously so. Anyone who is in any way in public life, including lawyers and including also legislators, as you know, knows that any initial story in the media about a complaint that has been filed overwhelms any follow-up story reporting that the initial complaint was of no merit and that the individual did not engage in any wrongdoing. In such a situation, disclosure of the complaint will have caused reputational damage that cannot be erased. Thus, early disclosure of complaints against lawyers is unfair to those who, in the end, are found to have done absolutely nothing that supports discipline. We recognize, however, that there are situations where the public should be made aware of the questionable conduct of a lawyer without waiting for a final determination of the disciplinary body. Clients who retain a lawyer during the pendency of a disciplinary proceeding or continue to be represented by a lawyer during this proceeding may be harmed in some situations if they are unaware of serious charges that have been brought but have not yet been finally determined. The State Bar Association has considered these issues on several occasions, with at least 3 different committees having examined the matter within the last 15 years. While, as an association of attorneys, we want to protect our members, we recognize that we also have an obligation to make certain that those represented by attorneys are not harmed. In light of all these considerations and the recognized competing interests, the State Bar Association has concluded that where there is a need to safeguard the public, the appellate divisions, which are in charge of lawyer disciplinary matters, should exercise the authority they already have in any appropriate disciplinary case and consider interim suspension of the subject lawyer pending the outcome of the disciplinary process. With suspension comes public disclosure. This proposal achieves several objectives. First, in those cases where allegations have been made against an attorney which are not serious or for which there is not significant supportive evidence, the attorney is protected. His or her name will not be revealed unless and until there is a public discipline, meaning that disciplinary action beyond a private letter has been addressed to the attorney. Where public discipline is not warranted, the fact of allegations having been made and the results of the disciplinary proceeding would not be revealed. The attorney's reputation would remain intact. However, to protect clients and the public in those cases where serious charges are brought and the initial evidence is supportive of those charges, the courts would step in and make a judgment as to whether suspension and public disclosure is warranted. This would be a determination made by the judges of the appellate divisions on a case-by-case basis. This would place the decision as to whether to suspend and disclose exactly where it should be with judges, whose fundamental role in our society is to examine individual cases and make decisions based upon the facts placed before them. I am aware that there have been general calls for increased disclosure of disciplinary proceedings. However, I do not believe that those who have called for such disclosures have done the careful analysis that has been done by 3 Bar Association committees, nor have they acknowledged the competing interests that need to be reconciled as I have outlined them. The law recognizes that certain proceedings need to be confidential to protect innocent parties from being tainted. Grand jury proceedings are the best example. They have been secret for centuries in recognition of the need to protect innocent parties. Similarly, while the courts are open to the public, certain cases, such as many family court cases, are not public. The legislature has recognized that there are situations in which the need for confidentiality is superior to the desire to have a public disclosure in a democratic society. In conclusion, the State Bar Association recognizes that disclosure is necessary in certain circumstances. Where clients and the public need to be protected, we want the courts to use their power to step in, suspend an offending lawyer, and disclose to the public. However, absent a finding by an appellate division that there is a need for immediate suspension and disclosure, the association urges that disciplinary proceedings not be open and that disclosure be made only where there is a finding that public discipline is warranted and that an attorney has in fact done something wrong. Innocent lawyers need protection as much as other innocent parties, and our proposal offers both lawyers and the clients they serve the protections to which they are entitled. Thank you, sir.
So, thank you very much. I'm very interested that you at least, and the association recognizes there is some need, I guess, to deal with the perception, but most of all, having the public have faith in a system like this.
I understand public concern about the issue.
But at the same time, we have to, those counsels who have done good jobs and just to be labeled for complaints that should be dismissed or shouldn't have, or frivolous in its nature at the same time. So what we're trying to do, 2 competing concerns.
I do understand that. And I also recognize the fact that there are complaints that are filed with, I've been involved in the grievance process for a number of years. I've been involved in the disciplinary process for about 19, 20 years, off and on. And I recognize that complaints are filed. It's easy to make a complaint about a political person or an attorney or a political person who is an attorney, particularly at election time or during the proceedings that predate election day. In other words, a campaign time. And that's a very difficult time for an attorney who is running for political office. You need only look at the television channels in the last few days, the last few weeks, about this man in New Jersey who was a former United States attorney who has become the subject of a complaint of pay to play. And I don't know whether he's done that or he hasn't done that. But if he hasn't done it, his reputation has been badly besmirched. And it happens over and over and over and over again. I recognize the need to protect the public. I certainly would want to protect the public. I must tell you that neither my association nor I suffer wrongdoers lightly. But I think there is a two-way street here.
So thank you very much for your comments. Thank you. The next person is John Aratakis.